Thank you, Bob. We've renamed the case Perry versus Brown. We got to do that because the new governor is named Brown and not Schwarzenegger, but it also seemed to be a felicitous development in the case. I cannot say with adequate words how grateful I am for this award. Bob, thank you for those kind remarks, and thank you to everyone at Whitman-Walker for involving me in this process and singling me out for recognition for what we've been doing. I mean, so many lawyers at Gibson, Dunn & Crutcher and Boyschiller and Flexner and so many other people that have been helping us. I think you'll find out in a few moments that David Boies is not going to be here today unless, in the last hour or two his schedule changed. David, I love working with David, but I can never tell where he's going to be. I was with him last Thursday night in Miami, and we flew back together, and then on Friday morning I was here and he was in New York, then he was going to Chicago, then he was going to California, and then he was with us again yesterday in Washington, D.C., and then he said he had to be someplace else and someplace else. So if David shows up, I apologize, but I do want to say how much I've enjoyed working with David Boies. He's just a spectacular lawyer, and he's maybe the hardest working person I've ever known. David and I and our two firms have worked together so closely. There's not been a moment when we haven't agreed completely with what we were doing in this case. And I will say this, we have felt from the beginning that we wanted to challenge the constitutionality of Proposition 8, which engraves discrimination against hundreds of thousands of Californians in the Constitution of the state of California, the largest state in the nation, the Constitution of California. We felt that it was exceedingly important to take down that kind of institutionalized discrimination that is a license to everyone in California and everywhere else to say that the people of California have decided that in its Constitution, in its governing documents, that gay and lesbian people and their relationships should not be treated as equals, that there is something wrong, something peculiar, something different, something unworthy of gay and lesbian individuals, and that it is okay to treat them differently, which breeds and encourages discrimination and harassment, and in some cases brutality, and for that to be a part of the Constitution of the biggest state of the United States is intolerable. And the trial of the Proposition 8 case was, we had 12 days of trial. We had expert witnesses that talked about the history of discrimination, the history of marriage, the damage that's done by discrimination, the raising of children, psychology, political science, economics. The case was so overwhelming that no one in that courtroom could not have been convinced that this was intolerable, unacceptable, and unconstitutional, and un-American. Even David Boies was brilliant in his cross-examination. Our opponents started out with eight. They stated that they were going to bring 8 expert witnesses to the trial. Before the trial started, they withdrew 6 of them. They withdrew 6 of them because David Boies and lawyers in my firm and David's firms had conducted videotaped depositions, and we found out that they couldn't really make the case that they were trying to make, and we wound up using the depositions of those 6, or many of those 6 expert witnesses in our case over the objection of our opponents who said that they were not qualified. And the 2 who did testify, David Boies then dismantled them, dismembered them in cross-examination, so that their 2 principal expert witnesses, including their leading expert witness, said that California and we would be more American when we recognize the rights of gay and lesbian citizens to be married. That was the testimony, under oath, of the principal expert witness on the other side. There was a videotape of that trial. The judge felt that it was a constitutional case, and that the American people ought to be there in that trial. If not present physically, they should see, the American people should see the evidence and listen to the case of against Proposition 8 and the case in favor of Proposition 8. The Supreme Court, for various reasons, prevented the distribution of that videotape. It was going to be streamed to other federal courts in the United States, but the videotape was made, and it was streamed to an overflow courtroom in San Francisco, and we used the extra excerpts of the videotape during the closing arguments that occurred about 6 months after the end of the trial. Now our opponents are attempting to make sure that that tape never sees the light of day. Why is that? They have various different reasons, but none of them are very good. If every single American could see that trial, which was an emotional experience beyond anything I've ever had in my life or in the practice of law, and in education, everyone who was there, gay and lesbian advocates, and everyone who was there, realized that we were getting an enormous education. We were privileged to be there, and if you learned and listened to what was going on in that trial, Proposition 8 could not stand any conceivable argument. And of course the judge agreed at the end of that case that there was no rational basis for this discrimination, that was doing great harm, and it did not accomplish any legitimate governmental objective. So I want everyone in this room to know that that videotape exists, and that someday it's going to be available. We're doing various things to make sure that the American people get to see, in one way or another, the reconstruction of the trial and reconstruction of the witnesses, because the plaintiffs testifying about what it meant to them to be the victims of this discrimination and not to be able to call themselves married with their partners that they've been with for many, many, many years. What it meant in their daily lives to them and their children to be the victim of discrimination, to be able not to describe their relationship in the same way that their neighbors could describe their relationship, to be forced to be answer questions every day for jury duty or for banks or for hotels or at the schools or when they were picking up their children. Who are you? And the damage that that's done. It was an emotional experience, and everyone in this country should see it. So let's everyone help keep the pressure on with the courts to see that videotape. And I want to say to Paul Smith, it is an immense privilege to be a part of an award ceremony involving Paul Smith, who I've admired enormously for so many reasons for so many years. Paul is an absolutely fabulous lawyer. He's done so much work in so many different areas, and is so successful and so respected by the justices of the Supreme Court and his colleagues in the bar enormously. But what he's also done, and what he and others have done to advance the cause of justice and respect and decency for all of our citizens, it's something that I admire a great deal. And you're right, Paul, that everything that we did in the Proposition 8 case built on things that you and others have done, including the Lawrence case, including that Justice Scalia dissent in the Lawrence case. And I was quoting that to the judge, and he said, "Well, that was a dissent." And I said, "Yes, but he lost." But he was honest about it, because he was recognizing the impact of the decision in your Lawrence case. And so Paul is not only a deep friend, but someone I admire, and the rest of the legal community has great respect and admiration for. So I hope I haven't gone on too long. Thank you so much for this.